Hello, everyone, and welcome to another edition of Crossroads, where faith and culture meet. I am your co-host, Rita Peters, and I'm here again with my co-host, Mark Meckler. Mark, how are you doing today?
I'm doing great. I'm super excited about this subject. It's kind of off our normal path.
Yeah,
And you and I both like that, right? When we can get into subject matter that maybe our listeners haven't heard before. So I'm excited for today.
I love it. And I love, Mark, that we have so many talented, super well credentialed experts just waiting to jump on our Crossroads program when we ask. We have today one of our favorite guests with us to talk about a First Amendment case that is currently pending before the U.S. Supreme Court. Our guest is Michael Farris, and he is now a fairly regular guest on Crossroads. So I'm not going to give you his full bio again, but I'll just remind you that he is a widely respected constitutional lawyer who has litigated extensively in the federal appellate courts and before the U.S. Supreme Court. Mike, welcome to the program.
Mark, Rita, it's always great to be with you.
Now, Mike, in addition to your current work as senior advisor to Convention of States Action, you also serve with the National Religious Broadcasters. I believe you're general counsel, right, with National Religious Broadcasters. Tell
That's
our
right.
listeners briefly just about that organization in case they're not familiar with it.
Well, NRB is an organization for Christian communicators. Radio and television was the origins of it, mainly radio back many, many years ago. But it's expanded to bloggers and podcasters, and there are thousands of members. We just had our annual convention in Nashville a couple of weeks ago, and there were about almost 5,000 people in attendance. And so its basic purpose is to preserve the freedom to broadcast and deliver Christian messages to the American public. And that's been under attack over the years, and it's under attack, kind of currently in a variety of ways, more subtly than some attacks in the past, but deplatforming is a real issue that Christian broadcasters are concerned about with YouTube and other kinds of broadcasters of that nature, or forms of that nature. So.
Now, the case we want to discuss today is called Murthy versus Missouri. Mike, we'll get into the specifics of your brief and your argument in a few minutes, but can you start just by giving us some background? What is this case all about?
Well, this case was brought by the states of Louisiana and Missouri by their attorney generals, both of whom are good people and who I know, and a collection, a handful or so of private parties, all of whom had their messages suppressed by the Biden administration on a variety of topics, COVID issues, vaccine issues, Hunter Biden laptop issues, just a variety of issues. And the evidence demonstrated that the Biden administration and various agencies, including the State Department, Dr. Fauci, and many others, were meeting regularly with the leadership of the various social media groups. And the point of their meeting was to suppress messages they didn't like. And so if they didn't like a particular thread of an idea, they would write algorithms to try to kill that idea. If they didn't like particular people, they would kick them off their various platforms. And the White House and other arms of the federal agencies were very much active in partnering with the social media organizations. There's a general rule that the First Amendment only applies to the government. But when private parties are active partners with the government, then the First Amendment, in theory, applies to the whole enterprise. But in this case, the lawsuit only sought to stop the federal government from twisting the arms of these various social media organizations. And so That's the background. That's what was going on.
Hey, Mike, I want to jump in and get a little more clarity on the First Amendment. One of the things that I see online all the time, we know Facebook censors people like us and Instagram and wherever else people might be posting. Maybe not X, but I think some of that's still going on inside of X right now, despite Musk's best intentions. And I hear people, or I see people writing all the time, I have a First Amendment right, and Facebook is squelching my First Amendment right to speech. And you sort of touched on this a little bit. If Facebook says, I want to kick Mike Ferris off my platform, there's no government involvement. Is the First Amendment involved at all in that?
No, the government is the only agency that's aimed at by the Bill of Rights. In fact, generally speaking, the Constitution grants power to government and limits power of government. It does not control private behavior with almost no relevant exceptions. So, owning slaves is the only relevant exception. No, that's directly controlled by the 13th Amendment. But other than that, it's really aimed at government. And so now it doesn't mean that it's not illegal for Facebook and others to do this to people, but it would be a different source of law and not the First Amendment. For example, the consumer protection laws. If Facebook promises an open forum and isn't going to harass you or limit you because of the substance of your views, then when they do that, they are violating the consumer protection laws. They promise one thing and they don't deliver. And make no mistake about it, you are the product. Selling information about you is what Facebook is all about. And so that's their principal, or at least a principal source of revenue for them. And so so it doesn't mean it's not illegal. It's just not a constitutional violation.
And then I want to one more crossover question there, if I could, Rita.
Sure.
We talk about the First Amendment a lot as Christians and as conservatives, something we're really strong on. I think sometimes people get confused because here we're talking about freedom of speech. That's not all the First Amendment covers, though. There are other areas of freedom covered by the First Amendment, right?
Right. There are 5 particular freedoms in the First Amendment. The free exercise of religion, the prohibition against the establishment of religion, freedom of the press, freedom of speech, and the right to petition for redress of grievances. Actually, there's 7. I forgot to. And freedom of association, and there's one more, but it just is evading me for the moment.
So in this case, what we're dealing with is the First Amendment protection for freedom of speech from government interference, right?
Exactly. And so the question before the court, frankly, is how much coercion can the government put on you, put on these agencies to try to suppress protected speech by private individuals or state governments, for that matter. And so it's not a question of whether or not the agencies, the Twitters, the Googles, the Facebooks, and so on, where they violated the law. This is entirely aimed at stopping the government from interfering with people's freedom of speech in these contexts.
Yeah. So, Mike, there's no question, right, that the government couldn't have suppressed this speech directly, because we're talking about singling out a viewpoint that the government didn't like and didn't want spread, and specifically suppressing that. So talk a little bit about that. And then if you would just tell us about the approach that you took in your brief for the national religious broadcasters.
Sure. The general rule is the government can't suppress speech at all unless it's one of the very limited categories of things. For example, publishing military secrets would fall into a recognized exception of the First Amendment. Defamation is a recognized exception. Now, a defamation is almost exclusively punishable after the fact and is not subject to prior restraints, which is a prophylactic effort to try to prohibit somebody from saying something in advance. Obscenity is is not protected speech. Fighting words, but so we're not following with any of those areas just because they don't like what you say about COVID or government policies or the Wuhan labs or the effectiveness of the vaccines or that the stupid masks don't work at all. They can't censor any of that. It's all protected speech, but it's particularly even if we were in a zone where the government could regulate it. Let's say we're talking about a forum uh, in a public university. They rent out their facilities to people, and in that public forum, they make a discrimination on the basis of content. That they can't do. I mean, generally speaking, they don't have to open their building to a public forum, but if they do, then they can't do content-based rules. And so, content-based is such an egregious violation of the First Amendment that the government can't do that even in their own buildings and in their own forums where they have some right to control what's going on because it's their building, in an operational sense at least. And so this is way, way out there because we're in the private context and it's content-based rules. So it's a double whammy why the government can't be involved here.
Yep. And I just want to clarify for our viewers, listeners who aren't super familiar with Supreme Court practice. You wrote and submitted a brief on behalf of the national religious broadcasters. They aren't actually a party to the case, but this brief is what we call an amicus brief or a friend of the court brief, which is an opportunity for an organization like NRB to offer to the court other points of law, present novel arguments that maybe haven't already been presented or briefed by the court, right? So that is an important opportunity. And if you would just share maybe how the approach that you took in your brief might be different from what the actual parties have to argue.
The brief that I filed for NRB in this case argued that the Fifth Circuit got a good start, but they didn't go far enough. They had argued in the Fifth Circuit, the court did, that the government coerced some agencies in some particular instances. The White House was engaged in actual coercion. Dr. Fauci was engaged in actual coercion. But other agencies, like the State Department, were engaged more in suggestions that the Twitter and Facebook and other platforms should suppress speech, but they didn't really coerce them. And so, they drew a line between coercion and suggestion. My argument was that the First Amendment does not permit the government to ever even suggest that somebody else's speech should be suppressed. The justification for the government doing this is the government has the right to speak. And true, the government has the right to speak. They can say, this guy's view on vaccines is wrong. This guy's view on such and such is wrong. Here's the truth about the Hunter Biden laptop. Talk all you want, say anything you want, but the government can never, not ever say, don't print somebody else's viewpoint, because that is not a legitimate government purpose. And every law is unconstitutional if it serves no legitimate government purpose. And the suppression of speech is never, ever a legitimate government purpose in the context of protected speech, which this is entirely it. So I just was trying to draw more of an absolute line, and I hope the court actually goes there.
Mike, I have a question because it seems to me that you're dealing with a novel area of the law here. I've heard it talked about a little bit, but I'd like you to get into this, which is, I think it's called state actor theory of First Amendment law. In other words, you have the state intervening here in private companies. So this is not pure what we normally think of as First Amendment law. You described that earlier. The government suppresses speech directly. Now you have the government influencing in a variety of ways policies of private companies to do things that the government would not be allowed to do. And I think it's important people understand there's a continuum here. Is it a suggestion? Is it coercion? Is it a demand? Where does it fall on the scale? Does that make a difference? But the real, I think, crux issue is, does a private company become a state actor because the state is either compelling or cooperating with them? Isn't that what we're talking about here?
Well, it's an important concept in a broader set of circumstances, but not really for this case. Because in this case, the only issue is, can the government itself tell them to suppress speech? It's not a suit against Google. It's not a suit against Facebook. If it was a suit against Facebook and Google, then the government actor doctrine comes into play. And I actually think then that the line drawn by the Fifth Circuit would make more sense. That, is the government your partner just because they make a suggestion? Probably not.
Mhm.
But if the government is hand in glove with you, and I don't think coercion's necessarily the right standard for the state action doctrine, but it should be kind of a hand in glove kind of an approach. Are you guys really working together? And if you're really working together, then you can also sue the First Amendment violations and blame Google and blame Facebook and sue Meta, and so on. So I don't think that that's going to be the same outcome as this case. This case is simply, can the government coerce them, tell them, suggest to them that they shouldn't print somebody's speech that the government doesn't like? That's a pretty clean case, and something that's pretty rare because
Right.
it's so totalitarian that we really don't have much history of the government doing this kind of stuff.
Yeah. Mike, so much of the marketplace of ideas, as we call it, today is contained in social media. It's Facebook, it's X, it's all in social media. That's how we communicate. That's how ideas spread to a large degree. But since the framework for the protection of free speech in our country does really stem from the First Amendment, would you say that today our speech is less free? Is it harder to, protect or have equality of treatment of ideas in the marketplace of ideas because so much of it is happening on private platforms today?
Indeed. Now, the reality is that the social media platforms have become the common carriers of our age. And it's illegal for the phone companies to censor you because they don't like what you're saying on your phone lines. They have to offer phone service to everybody because they're a common carrier. Now, there's some government action involved in that. The phone companies got special right-of-ways to string their lines and other things. So that was the justification for this kind of government regulation of the phone companies. Otherwise, they're just a purely private business and they don't get government partnership in any way. Well, they did get government partnership. But what we don't seem to remember is the government was involved in the creation of the internet, and that it wrote the protocols. And the entire structure of the internet is written upon a government backbone. And so the idea that there's no government involvement here is nonsense. They really do need to dig deeper into the technical creation of the internet so that they know that the common carrier doctrines really should apply here in full force. It's not nearly as private as we think. There's more government involvement. There's more government funding. And so, and it's just simply a rule of freedom that should attach. That, we're not saying that the government should gain control over it and get to do anything they want. But no, if you're going to create private platforms and you're going to market to people, then I think that we're going to get the same result. I think you get to almost the same place by consumer protection laws, because all these places advertise that they are not going to discriminate on the basis of viewpoint. And that is just simply laughably nonsense because, based on the way that they actually operate.
Mm. Well, if I could just follow up with one more question, Mark, it certainly seems more complicated to make sure your speech is protected and your viewpoint isn't discriminated against. So is that true? Is it harder to like untangle the layers of, well, how do I make sure my viewpoint isn't suppressed? And does that make it harder to find truth in today's marketplace of ideas?
Uh, yeah, now we're going into the real deep philosophy. How do we find truth? Pilate didn't seem to know that either. Uh,
You
and
can
and
wrap that
so
up for us, Mike. Come on.
yeah, first of all, what is truth? Jesus is the way, the truth, the life. No man comes unto the Father but by him, and that's the big truth here. Now, scaling down to lesser truths, the government doesn't really care about truth in the rightful sense, unfortunately, and it shouldn't be in the business of deciding what is true and what's not true. That's for people to decide. The hearts and souls and minds of men belong to a relationship between the individual and God, and never to government. That's the essence of what the First Amendment is all about, is making sure that ideas, thoughts, beliefs, words, communications, all that whole area does not belong in the government sphere. Congress shall make no law respecting an establishment religion or any of these other things, violating so it's a no law rule. And so that's the ideal, that's the standard. But the interplay between that and a bunch of private enterprises that built on a government backbone are controlling our ability to communicate, that's a lot more complex. And so our opportunities are more complex. Our diminishment of our rights is more complex as well. It's all more complex. But the good news is, even with all this bad stuff, we still get a lot of truth out there. There are still more opportunities for truth today than ever before.
Yeah, Mike, I have a question for you. You mentioned that there's potential consumer protection implications here. I started many years ago. Part of my career was drafting these policies and conditions and terms and conditions for social media companies. You and I both know nobody reads those things. It's just tons of boilerplate, small print stuff that regular folks wouldn't understand anyway. They're drafted that way intentionally. If the social media companies just put into that boilerplate that they can discriminate on the basis of viewpoint, then all that consumer protection stuff would go out the window anyway.
It could, yeah, until they go in front of Congress and say, no, we don't do this. Because they publicly declare that they're even-handed, and so the boilerplate wouldn't override their admission in a congressional hearing, which pretty much all of them have done. But no, if they were really clear to everybody, we discriminate. We're only going to let left-wing ideas be promulgated here. You can do cat videos and left-wing ideas. That's your thing you can do here. Then okay, then the consumer protection law wouldn't apply. But if we, I think we should be really considering laws that make this essentially a public forum. And the common carrier kind of rules that apply to the telephone company, I think, should apply to the internet.
That's a great point. Mike, I want to go broad and transcendent again. The First Amendment is surely one of the most common denominators in terms of core American values. We all love the First Amendment. I think every American would say that. But tell us in particular about why the freedom of speech, which, as we explained earlier, is only one of the multiple really important freedoms protected by the First Amendment. Why is the freedom of speech so crucial to the maintenance of a healthy republic?
Well, just as a matter of First Amendment interplay, the freedom of speech really connects to all of them. Pretty much, the free exercise of religion, the ability to preach the gospel. Well, that's freedom of religion and freedom of speech. The ability to publish a newspaper. Well, that's freedom of the press and freedom of speech. Why are we associating? So we can get our messages out. That's freedom of association and freedom of speech. And so the freedom of speech really, is an interplay with everything. And the reason this all came up, and the reason that we even have the First Amendment, there's a deeper battle here that I wrote in a book called The History of Religious Liberty. It was the ability to get the Bible into the hands of the common people in their own language. That's where this all came from, because the government was suppressing that. There were prior restraints saying, no, you can't translate the Bible, you can't print the Bible without the government's prior approval. And if they don't like your version or your translation or other things, they don't like whatever book you wanted to publish, all of that, the whole structure of freedom of speech, press, and other things came from the desire to put the Bible in the hands of the common people. And so, we really have to thank the people who, the people like Tyndale and other Bible translators really laid the foundation for all these freedoms. But they work with each other, and speech really is common to every form of enterprise, the gospel, newspapers, radio, television, everything you can think about, speech is involved.
Mike, I know this is a question that lawyers never want to answer, so I got to ask you, which is, give me the odds on this case. How do you think it ends up? What do you think our odds of winning?
Well, I think the 3-2 with 7 points to the Gonzaga Zags. I think that some form of affirmance of the Fifth Circuit is going to happen. Now, will they go really strong, or will they piecemeal it? That's really the issue. I think the smart money's on that the Fifth Circuit's going to be upheld in some way, shape, or form. But even that's not a guarantee. I can do better in predicting after I hear the oral arguments, and they're coming up in a few weeks. I'm rarely wrong on those, but I get surprised.
Can you summarize for us what the Fifth Circuit said so that our listeners understand?
The Fifth Circuit said when the government twists the arm of these companies too strongly, that violates the First Amendment, and they ordered the government to stop it. And so they can still meet with them. They can still, get their own viewpoint out, but they can't coerce.
But we're hoping that the Supreme Court goes even further and says the government can't take any action that is aimed at suppressing protected speech. Is that right?
That's exactly what my brief said to them. And with your prayers and the prayers of all the people watching, let's hope that that's exactly what the court does.
Mike, I have a question for you before we wrap about specifically that issue. If the court doesn't say government just can't do this, then they're going to end up creating some sort of mushy standard, right? Because there has to be some kind of a standard for the lower courts to judge upon, and saying, well, you can't really just influence them. That's not a standard. So what kind of thing could they issue that would be some form of rule?
Well, the Fifth Circuit's opinion plays this, this, or spells this out, and it's not very satisfying. And it's, we all know when the president, you're in a meeting with Twitter or Facebook. Let's just make it Facebook, and the deputy secretary of state says to the Facebook guy, the president of the United States would really appreciate it if you could get rid of this guy's account. Okay. Is that coercion or is that a suggestion? That's what we're talking about. And, and if wink and a nod, it really puts you into a really difficult position if you're trying to work it out in practical terms, because it's going to be like the student loan case. I mean, the Supreme Court said, no, the president alone can't forgive student loans, but what's he doing? Well, he's just doing it piecemeal rather than this broad thing he started with. And so that's nonsense. The government will try to come back and push the line and push the line and push the line. And so the time to tell them they can't do this at all is right now.
Well, we're going to have to wrap it up on that note. For our listeners, the case again is Murthy versus Missouri. Mike, you mentioned oral arguments coming up in a few weeks. When do you expect a decision on the case?
Before June 30th.
All right. Okay. Thanks so much, Mike Ferris. We're so grateful to have you working on important cases like this. Mark, thanks for joining me again today.
Thank you, guys. Bye-bye.
I also want to thank our generous sponsors at Blue Ridge Chimney Services, Blessings Christian Bookstore, Sunshine Ministries with Christian Radio, Wishing Well Florists and Travel, and our good friends at New Beginnings Church and Garber's Church of the Brethren. Thank you all for listening and for your financial support. If you'd like to make a donation to Crossroads, you can just send a check to Crossroads at P.O. Box 881, Harrisonburg, Virginia 22803. I'm Rita Peters with Mark Meckler, inviting you to join us again next week for another edition of Crossroads, where faith and culture meet.